tonight is to reorganize, and we'll start with a motion for the chair. Do I hear a motion for the chairman?
Pat, I nominate Pat.
Okay, John nominates Pat Kennelly. Can I hear a second?
Second.
Second by Babe. All in favor? Unanimous. Okay. How about a motion for vice chair? Could I have a motion for vice
I
chair?
move Joe Kellejohn to be vice chair.
Can I hear a second?
Second.
Second by, motion made by Babe, seconded by Pat. Vice Chair Joe Calgione. Let's have a motion for the clerk.
Vote.
Excuse me?
You have to vote on it. You didn't vote.
Thank you, Joe. All in favor of Joe being the vice chair?
Aye.
Unanimous. Make a motion for the clerk.
Nominate Karen.
Joe made a motion for Karen. Do I hear a second?
Second.
Second by John. All in favor?
Aye.
Unanimous. Motion made by MAPC SWAT representation.
Joe?
Who was
It was
that?
me last time.
Motion for Joe.
Motion made by Pat for Joe.
There wasn't any meetings
Do
anyway.
I hear a
so-
second?
Bill.
I was on, I'll second.
Second by John.
Yeah, it used to be
All
you,
in
but I think it was
favor?
last year.
Unanimous. Fair Housing
wasn't-
Committee Representative. Can I have a motion?
That
Yeah.
was Babe. Motion for Babe.
Motion made by Pat for Babe, second.
Second.
All right, we all-
Second by Joe. Okay. All in favor?
Aye.
Unanimous. Open Space Advisory Committee Liaison.
Was that you, Lena?
No, Joe.
No, it was me.
I think it was.
We can't have Joe do
everything.
There was no meetings on that either, so.
No. We'll
But
make
that's
a
fine.
motion for Lena.
Oh, for God's sake. Okay, Pat's got a motion out for Lena McCarthy for the
I'll
liaison.
second.
Second by John. All in favor?
Aye.
Unanimous.
And Joe, you're middle
Yeah,
school least,
that's,
right?
yeah.
Middle
yeah.
School
why I
East
said you can't have them
Reuse
all.
Committee Liaison. Can I have a motion?
For Joe.
Motion made by Pat for Joe, second by Babe. All in favor? Unanimous. Authorize clerk and town planner to sign correspondence for the chairman. Do I have a motion?
Motion.
Do I have a,
Second. Joe moved.
okay. All in favor?
Mm-hmm.
All right. Authorize clerk and town planner to sign the planning board meeting postings with town clerk.
I make a motion.
Motion made by Babe, second.
Second.
Second by Joe, all in favor? Unanimous. Authorize town planner to sign the 81P
Motion.
plans after board approval. Motion made by Pat, second by John, all in favor?
Mm-hmm.
All right. Authorize town planner to sign planning board payroll. Motion?
Motion.
Motion made by Joe,
Second.
second by Babe, all in favor?
Yes.
Unanimous.
The most important vote of the whole thing, right?
Authorize town planner to call planning board meetings and set public hearings. Motion?
I'll make the motion.
Motion made by
Second.
John, second by Pat, all in favor? Unanimous. Authorize town planner to set planning board agenda. Can I have a motion?
Motion.
Motion made by Joe, second by Babe, all in favor?
Yes.
Unanimous. All right,
Give your seat to Pat.
Thank you, Lena.
here's your seat, Pat.
I'll just stay right where you are. I'm fine.
Make a motion, we approve the minutes.
Motion made by Babe, seconded by Joe. All in any discussion?
One abstention, I wasn't here.
4 in favor, 1 abstention. Let's go right down to, there are no 81Ps, so let's go right down to number.
Who made the motion on the minutes? I was catching up.
I
That was
did.
Babe and seconded by Joe, sorry.
Go slow.
Let's go right to the amended site plan since we have a few moments.
2 minutes, 2 minutes. I got it right this time. so No variance necessary. Which kind of sounds familiar.
Let me just read this for the record. The applicant is requesting amended site plan approval to allow for the installation of a large-scale solar energy system on portions of the subject property. Such installations are permitted via site plan with the industrial districts, provided that they meet yard setbacks among other requirements. The subject property is a 6.78 acre commercial plaza at the corner of East Main and Fortune Boulevard. The applicant is proposing roof-mounted solar panels as well as canopy-type solar panels to be installed above certain portions of the off-street parking areas. All applicable zoning requirements appear to be met, therefore Larry is recommending approval. From the town engineer, she's reviewed the site plan and has no comments. The same with the highway department. The fire department also has no comments relative to this project, nor does the building commissioner or the water company or the Milford Commission on Disability. With that said, Bob, I'll turn it over to you.
Thank you. So if you can remember, we were before you previously seeking a recommendation to the ZBA, and at that point, they were going to install canopy-mounted solar panels along this area here, which was going to encroach on the side yard setback in the zone. Subsequently, they've removed that. We've added here, basically, the mounted panels now are gonna be on carports here, here, and here, and roof-mounted in locations here, here, and here. They all meet the zoning requirements, and they're not gonna really add any change to the site plan as far as impervious area.
Thank you, Bob. Questions of the board, from the board, rather? Hearing none, pleasure of the board.
Make a motion, we approve the amended site plan?
Motion made by Joe, seconded by Babe. Any further discussion? Hearing not, all in favor, opposed, unanimous. Thank you.
Floorhouse is out.
Oh, it is? That's good to know.
Warehouse is out.
Should be easy.
Yes,
Blair
Blair's
House,
off.
yeah.
As long as you're on the main agenda, the item for 20 Claflin Street being continued until the May 17th meeting.
Thank you, Larry. Seeing that it's 7:05, we will go right into the first public hearing. Larry, if you have an opportunity, please read the, good night.
Good night.
Night,
Good night,
Bob.
Bob.
Good night.
Good night.
Please read the posting, Larry, when you have a chance.
Got it. Milford Planning Board notice of public hearing on Tuesday, April 19th, 2016, in Room 3 of Milford Town Hall, 52 Main Street. The Milford Planning Board will, at the times designated, conduct public hearings regarding the following. The full application and/or maps of the above items are available for public inspection Monday through Friday from 8 to 4 at the Office of Planning and Engineering, Town Hall, 52 Main Street, Milford, Mass. Interested parties may express their views at the above scheduled hearings. The notices were published on 4/5 and 4/12/2016. The first public hearing is application to the Planning Board and the Board of Selectmen to amend Article 3 of the zoning bylaw by adopting a comprehensive revision of Section 3.9 sign regulations.
Thank you, Larry. Just for those out in the audience and those at home, essentially, this proposed article, or zoning bylaw article change, was born from last year's U.S. Supreme Court decision requiring strict content neutrality in all aspects of sign regulation. The upshot of that decision has been that we must focus only on a sign's physical characteristics and not on all of its message. To break our old habit of automatically thinking of a message on signs, we first establish new definitions to clarify what actually constitutes a sign. For example, official traffic control devices will not be considered signs for zoning purposes. This includes street lights, speed limit, stop and yield signs, street name, markers, etc. Second, we clarified sign location or placement to prevent anything other than those official traffic control devices from being installed within the right-of-way of streets and highways. Signs may be installed on lots or parcels, but not in streets. This will improve safety and reduce sign clutter. And finally, we address the physical characteristics of signs, including their type, size, height, lighting, motion, duration, etc. In this regard, the new regulations are in many ways similar to the current regulations. One noticeable improvement, however, is the provision of temporary signs for one-time events. These signs will be in addition to permanent sign allocation for a property in range from 1 to 4 temporary signs depending upon the season of the year. It is of no small consequence that the Board of Selectmen is co-sponsoring this article, and we thank them for their support. We have invested many months of work to offer the comprehensive amendment to the sign section, and that it is in line with the U.S. Supreme Court decision. That kind of gives you a quick narrative of the work. Obviously, there's copies of the article that was sent to town meeting,
Will be.
Or will be.
or will be, my apologies, town meeting members. This being that it's a public meeting, anyone from the audience have questions or concerns or comments relative to this? Mike, all I'm gonna ask you to do is come on up, and for the record, just state your name and address, please. Although I think Larry's already writing it down, but just for the record, please.
He's good. Thank you, Mr. Chairman. For the record, my name is Mike Visconti. I live at 7 Muriel Lane in Milford.
Thank you, Mike.
Keeping in mind, I have not seen the final draft of the zoning bylaw change for the signs yet. However, I have a concern / question regarding, I believe it's temporary signs, and is there a time limit on how long the signs can be placed?
Here's a copy for you.
My understanding that it might have been 30 days, but I don't know what the,
Here's one here.
I'll take that one. Thank you.
Is that the full package you gave?
I gave him the sign regulations, yes.
Yeah, oh, good.
Well, they can only be up during
Mike, are you
time.
referring to the
No.
seasonal signs that I'm going to,
Temporary signs?
temporary for clarity purposes only? Again, trying to remain content neutral, just for clarity purposes only. The signs that are typically allowed, if you will, during an election cycle, are those the ones you're referring to?
I am not, no.
Okay.
I guess I'm referring to any sign that any resident might want to put up in their yard.
Which is
The
allowed,
sign- Well, that sign could be considered permanent or temporary, depending on the type of sign. A permanent sign, there is no time limit on. Temporary sign, there really isn't a time limit on. However, there's only certain months of the year that the additional signs could be up. But there is no time limit, no.
On the temporary signs, there is no time limit.
Well, yes, there
There
is.
is, depends on,
It's-
There is a
let me-
time.
let me-
it depends on the month that they're in. There's no, go ahead, Larry, if you'd like.
The way the bylaw works is that you look to whatever zoning district a property's in, determine what the base sign allocation is for that. So if you're looking at the residential districts, you can have one wall sign or one freestanding sign, but not both, per lot, as long as it meets the other requirements in terms of height or area. And that's permanent signage. In addition to that, temporary signs, and again, it depends on which zoning district you're in, temporary signs in the residential zones would be, let's see, temporary freestanding signs relating to one-time events shall be allowed subject to the following. No more than one such sign should be permitted on the same zoning lot at any one time, except that during the months of March, April, September, October, and November, no more than 4 such signs shall be permitted on the same lot at any one time. And again, it gets into how many square feet the sign is, how tall it is. And to your question, Mike, Signs shall not be displayed more than 45 days before the event being announced, and shall be removed within 72 hours following the event.
Okay, thank you.
Yep.
But, which brings up one of my other questions, and that is of my concern with enforcement of those timeframes. How will they be enforced? Because as we all know now, there is little, if any, enforcement of the current sign bylaws as they stand now.
Right.
I think that's a good question, Mike. I think that one of the things that we were probably somewhat neglectful in the narrative that I read is that throughout this whole entire process, that the building commissioner has been a very active participant, obviously because he's going to be the ultimate enforcement agency, if you will. So he's fully apprised that he's going to be the enforcer, and he understands that there's specific times where other than one sign would be allowed. So it's going to fall directly on the building commissioner.
Okay, and with respect to the 45-day condition, there will be a permit required, so the building commissioner will know when that 45-day period starts?
It's spelt out.
45 before the event.
Before the event.
It's not, so the event, the date of the event is known. It's 45 days before the date of the event.
Okay. All right. One last one, then I'll leave you. Currently now, our our sign bylaws specifically prohibit off-premise business directional signs. Will this new bylaw affect that in any way?
Well, again, it's not
It's content
content-based.
neutral.
It's content neutral. So
So-
again, you look at the zoning district in which the property's located, that'll tell you what the sign allocation is for any given property. So if you have a business that might be allowed, let's just say 4 or 5 signs based on their particular zoning district, if they want to waste their signage, so to speak, and not be able to have signage for their own tenants, that's up to them. The bylaw does distinguish in terms of the placement of any signs between whether it's in a public street or private or highway street right-of-way or not. So you're not going to be able to put signs in the street. The only thing that'll be allowed in the street are the traffic control devices.
There's no
You can only
magnitude
put
of doing
signs
that, Mike.
on lots.
Which gets, once again, back to enforcement. Currently, as we sit here, and I won't name names, but I know of at least
It's littered with
4
signs.
off-premise business
That's
directional
correct, it
signs
is.
that are
Hopefully
in
that'll
direct
be
conflict
straightened
to
out.
our zoning bylaws.
Correct.
So, I'm
But
getting back.
those won't be in the future.
Those should be prohibited.
We have, they can't be prohibited, because if you allow signs, a person, if you're talking about a sign in a residential area, a person has a right to put up a sign. He has a right to put anything he wants on that sign. So if he wants to say in front of his house, "Eat at Joe's," I don't have Joe's, but that's okay. He can do that. He'll be able to do that in the future. There's nothing we could, there's no way we can stop that.
And that could be a permanent sign,
That's correct.
as long as it
Yes.
met the criteria for
Yes.
size and shape. and height and
Right,
all
because
that.
otherwise, we did not feel, the board discussed this significantly, was that, there's a lot of permanent, semi-permanent type signs that people want when people are selling a house or whatever, that we felt you had to allow. We can't discuss it anymore as terms of selling a house. That's just a sign. If we're going to allow people to have that sign, they have the right to put any notice they want on that sign. So that's why we can't distinguish if someone wants to put a business sign in their personal property. That will be legal. But they can only put so many, and they can only have it during certain times of the year. That's all we could do with it.
Okay, thank you. And that's all I have. Thank you for allowing me
Okay.
to comment.
Enforcement really won't change, Mike, the other thing. I mean, again, all the zoning is enforced by the building department, and that's where it all goes back to. I'm sure, I think the building inspector, in conversations that, we've asked for his input, as Pat said, I think he hopes that this will be a little bit more enforceable than the past bylaw, and that it'll make it a little bit easier on him. The fact of the matter is, in any sign bylaw, in residential property, personal property, the only actual mechanism is to actually go to court. The building inspector can't enter private property and take a sign down. He doesn't have the legal right to do that. he can give notice that somebody is doing something against the law, but he physically cannot go down and take down a sign in private property.
I understand that. I said I was done, but one last one. These signs that you see now plastered all over utility poles.
You're illegal.
They're illegal.
and under the
Illegal
new-
now, and they'll be
under the new
illegal, yes.
bylaw, they will be
Yes,
not
yes,
allowed
because
on-
They're illegal already.
most of those utility poles would be in the right of way, which makes them illegal automatically, because they're not signs, they're not traffic control devices. If there is a utility pole in someone's private yard, that's a different story, but the ones that are in the right of way would make those illegal.
I understand, thank you. And thank you, Mr. Chairman, again, for allowing me to
Anytime,
speak.
Mike, thank you.
Okay, Mike, thank you.
Any other participant from the audience? Any questions, or discussion from the board?
Make a motion to send
I
in
figured
favor.
I'd ask.
We've been over this for over a year now. I think we're ready to.
I know, I just didn't.
Joe, you made a motion?
Make a motion to send a favorable recommendation to town meeting.
I'll
Motion
second
made by
that.
Joe, seconded by Lena. Any further discussion here or not? All in favor? Opposed? Unanimous. Larry, when you're prepared, if you could kindly read the second public hearing.
I figured no one was
Do
gonna.
I have anything on that, Larry?
Yeah, there's one sheet.
Right there, okay.
He's gonna present it.
The other thing I would do on that narrative is that
Well, yeah, we can, that wasn't the final version.
Yeah, because
All right, second,
Seen her a little while ago, they're gonna send it with the warrant.
second public hearing is a application,
Send this right up.
the application of 5 Water Street LLC to amend section 2.3 use regulation schedule of the zoning bylaw relating to the use by special permit, relating to uses by a special permit within the OR Office Residential District. Take it,
Is
Ernie.
this it?
Chairman?
Mr. Pettinari, for the record, if you could just
I'm
introduce
Ernie
yourself.
Bettinari. My law office is at 12 Main Street here in Milford, and I'm here tonight with Fred and Lisa Carnero, who are the principals of the Water Street Meat Market LLC. With all of your connections to town meeting, you might remember that last annual town meeting, we successfully requested and received from town meeting an additional package license for the sale of beer and wine, which the Carneros have implemented at their store. As part of their business plans, the Carneros also have acquired the property next door to their store, which is located in the old Davern's Pharmacy at the corner of Water Street and Congress. As they furthered their plans, we had some conversations about the problems created by the current zoning. The current zoning being the office residential OR zone does not allow them to utilize the building, which had formerly been the walk-in clinic, as part of their retail sales and service in connection with their meat market. We talked about that for a while, and then I came and I sat with Larry, and Larry devised a proposal whereby the Carneros could seek town meeting action to amend the zoning bylaw so that in the OR zone, the retail sales and service use could be available to them upon the issuance of a special permit. That's what we're here tonight to talk about. I've been around a long time, as I think all of you know, and I know that the zoning bylaw is a living, breathing thing. And one of the things that I think is indisputably true is that the present use of their store and the proposed use of the building next door as part of their store is something that I honestly believe is in the best interest of the community. And other than that it is not a permitted use in the OR zone, we wouldn't be having this conversation. But because it is not a permitted use in the OR zone, we're here tonight to seek your support to present this article to town meeting. The town meeting will be asked to amend the bylaw so that the retail sales and service use would be allowable upon the issuance of a special permit, upon the findings of fact that are enumerated in what is proposed to be footnote 27. And that would be that we are talking about, and I'll read it to you so I quote it exactly, the special permit authority finds that the uses are proposed within existing conforming non-residential structures, so we're not gonna be talking about residences, and are consistent with the historic development pattern in the immediate neighborhood. We think this is exactly on point for what the Carneros seek to do. Go ahead.
I think it's also important that you cut yourself short and can provide adequate off-street parking, I think, is something that
That's
speaks
also
volumes.
very true.
There's also a method, if you will, that had we not created the OR and carried it into that, you perhaps would not be in front of us tonight.
Absolutely true.
So,
And there,
I'm being fair and equitable, that
Yeah.
I think it's noteworthy to at least point that out.
yeah, and there had been, and again, not any declination of responsibility on the part of the Caneros. There had been some confusion as to the zoning of the building during the period of time in which they had negotiated for and ultimately purchased the property. But clearly, the rezoning that
Had it not been rezoned, that you, again, would not be
they'd
in
have
front
gotten
of
a
us.
permit and they'd be using it. So again, I'm
My
comfortable.
point to this is, previous to the OR zone, it would have worked fine.
Exactly
And again, with this, I guess to your point, with this special permit revision, I don't see how it's a detriment, I guess is what.
Well, that would be
I guess
my
is what
position.
I'm suggesting that you are correct.
And in connection with this property, there had been a period of time in which the properties had been commonly owned. The driveway access between them is common. There's a lot of reasons why in this particular instance, we believe we can satisfy the special permit granting authority and satisfy all of the footnote requirements. So that's basically the approach. And we are prepared to, with your blessing, we hope, take that to town meeting and see if we can get the authority to use it.
Thank you, Mr. Pettinari. Questions from the board?
I just have one question, that the building where the medical offices were, what will be in that building? Do we know?
I think they just said they were moving their business. in.
They're gonna use it as-
They're moving from the old Davern's Pharmacy into that building. Is that what I hear?
I'll let Lisa answer that, because she can answer more accurately. As I understand it, what's going to happen is they're going to be utilizing both for
Oh,
a period
okay,
of
that's what I
time.
wanted to know,
Yeah,
yeah.
is
Okay.
that-
That's
that's
what
fair,
they
right?
said.
Yeah, we eventually want to, completely relocate to the 5 Water Street. 'cause
Okay.
Larger
it's bigger,
location.
Yeah.
It's bigger,
Yeah,
that
it's a lot
area is
bigger,
small.
yeah.
Okay. I just wanted to know if you were using both all the time, or eventually you would be
No,
going
eventually
over.
just that one.
Run back and
Just
forth
curious.
across the parking lot.
Thank you, that's all I have to say, Pat.
Any other questions from the board?
I guess in that location, I don't have an issue. The problem is this is a zoning change. And I'm trying to think if there are any other locations in the OR that this may allow the change where we really wouldn't want it. And I know we have special permit granting authority, I understand that, but it becomes awful difficult to say no to somebody and try to differentiate the locations or not. And I'm just wondering, Larry, if you had taken a look in whether you feel that there are other locations that this may be used or not used. The OR that we have where there's all residences, this gets eliminated, so I don't have to worry about it. But I'm trying to think where we may have other situations that this may be
Well,
used.
in the immediate neighborhood, anything that's not already residential or office was made non-conforming with the very zone change that created this predicament for this site. So the answer in the downtown OR zone is no. There may be one other potential site near Milford Regional,
Yeah, that's what I was thinking.
but it's, just given the whole nature of that area, it's a lot less likely that would ever come up. And it's, again, the uses that are there are already non-conforming. The uses in the OR zone right now on Water Street are this particular use at 5 Water Street's a conforming use. It's an office use. So I don't know of any other situation, even around the medical center, where that's the case, that this would
Right.
really come about.
I mean, my main point of asking in this is I don't want
Off-street parking.
this type of use in the OR zone going forward. I mean, that is,
Well,
that's
that's why
exactly
it's-
what we didn't want to do, is I mean, effectively, you have a spread where we've we've talked about revitalizing the downtown and using it for that stuff, and now we're taking and allowing, possibly allowing for commercial type uses outside of the core, and that's definitely not what we want to do. If
Well,
we're
that's
not really
why-
opening that up, then I
That's why
don't have
it's
an issue
so
with this one.
narrowly drafted that,
And we-
it's hard to find a site that
We
this
did look-
explains.
We did look at the rest of the zoning district, and to be, again, without scientific evidence to back me up, I'll tell you what I think, based on what we looked at. I don't believe there would be another appropriate vehicle for this kind of special permit when you add in the criteria that the footnote imposes, especially the parking. Because there's nothing that has the area that we could see in the immediate, because what I did, to be honest with you, Mr. Calagione, is when we talked about this, I looked at the zoning change, and I looked at the map, and I looked at all of the parcels that were involved. There isn't another parcel, to my recollection, that would have sufficient area in which we could satisfy the parking requirements, the conditions of non-residential, and the conditions of, consistent with the non-residential neighborhood criteria. So that's why, when Larry and I sat, there's absolutely no objection to the footnote stuff, because we support that. But in this particular instance, they own a building that would be ideal for what they want to do there, and would be a continuing, avail them of the continuing association with the community. So that's why we're here.
So it would have to be not only a non-residential structure, but an existing conforming non-residential structure. So it's hard to find that situation in either of the two office residential zones we have now. And I don't know, I suppose there may be a slight possibility as we expand the downtown office residential zone to move around
Right.
the center of town.
Yeah, we'll need to be aware of that
my
going
donut
forward.
theory of zoning, which I thought was quite appropriate.
Considering the office.
Considering, yeah. So it's really narrowly crafted to eliminate virtually anything other than what you're looking at.
Well, we got Carl Bright's,
Yeah, it's conforming, yep,
that's part of the OR, that could,
yep.
you could have parking there and have a retail.
But it's a residential structure.
It's not a resident, is it?
It's a,
Residential structure.
It is.
That's a
I don't think
wide.
that's a residential.
That's a wide definition. It's not, if it's not being used as a residential structure, it's not a residential structure.
What about upstairs?
The dentist's office there, I think that's all just down from there. I think that's all business in that.
Right.
but that's conforming, yeah.
The,
That's what the zone is for.
I understand, but they have enough parking there and everything, so they could do the retail.
That's why it's a special permit.
I understand
No,
that.
but
I'm, and like Joe, I'm very leery about giving out a special permit. Period.
But in the cases that you mentioned, Mr. Ionetti, neither of those would be an appropriate locus for the special permit. The insurance agency is already being utilized in a non-conforming way. So that, I would submit, could continue to be utilized as an insurance agency. And the
No, that's conforming, that's in the zone.
And the
But
dental
you could
office is
also put a but because it's being used as a non-residential use, it's possibility you could put somebody could apply for a retail.
Well, aren't they retail now?
They are retail, that's my question.
I don't think retail, I think it's office.
Office, professional office, yeah.
I think it's retail.
Bright,
Well, okay.
Bright Insurance, well, by definition, Bright Insurance is a,
I stand corrected.
Retail
it's
office.
not a, well, it's a professional
Again,
office.
that's
If you
why.
go in
we-
there and drop a check, it's retail, I'm sorry,
That's
but
why we went there, this is one of the things, I thought this was an excellent rezoning.
We don't say it isn't, just to be clear, we don't say it isn't. What we're here only to say is that it makes the proposed use of that property, which we think would be an excellent use of that property, impossible. There's no other relief they can get with regard to the use of that property.
I understand that. What was the zoning of the, that telephone, that building before we went to OR?
CA, wasn't
I
it?
think it was CA.
Was it,
Yeah, it
It
was
was
CA.
either CA or CB.
I don't know about the phone building. Their building was CA, because there was a
It's average, yes, I understand that.
No, and the one that they bought next to it, because there was a
That was a phone office for us older
Okay.
people.
That's what.
Then that was on CA. The reason I know that, Babe, is because up until the time they closed on it, they had been looking at the town's website, which was inaccurate. And again, that's their responsibility, nobody else's. But I know it was CA.
Again, I understand, they run a great business and everything, I just, the idea of special permits, just,
It would be tough to get it in Bright and have adequate parking if you went to, if you went.
Yeah, what do you have, five parking spots there if you're lucky?
yeah, I mean, you can make,
It's not the same, I don't think we're comparing apples to
No, I
apples.
understand, but I'm just looking at it, the dentist's office there, that's all commercial there. There's plenty of parking there. So you could, and as far as I'm concerned, that's non-residential because it's all professional offices.
Well, I think, and I think we need to make sure that we're clear as to what we view structure, non-residential or residential. Because when I read this, I would have assumed those, regardless of what's being used, to be residential structures. That this was trying to address structures that are boxes or whatever. So I think that's what the intent is. If the wording is incorrect or needs to be changed, I mean, we knew when we created the zone that there were non-residential uses within those zones, and the whole intent was to try to keep those residential look structures in there. So I think we can address those as being, the intent is residential structure regardless of what the look is, and that was my reading of it, so I would have gone that way. And I know what you're saying,
Yeah, I
that
just
they're
don't-
not using that, so
yeah.
I mean, I think we want to be clear that when we say residential structures, they're a structure that looks like a residence, not looking like a commercial or business type use. And then I'm fine with it, because
Yeah.
then those wouldn't fall in there. And I guess if you're fine with it, Larry, in terms of what residential structure works, and that's not gonna be a legal issue, then I don't have that much of a problem with it. Because that was my biggest thing, is I don't wanna take commercial away from the downtown core.
No, and clearly in this specific application, if we look at the store that they presently
Yeah,
have, it's storefront commercial.
Yeah.
Their new building, again, identical.
Yep.
Other than its size is larger, and then to the left of that, I think, is that the phone company or is that the
Yeah,
garage?
that's
It's
the old,
garage.
that's the
So-
old phone company operating.
I don't think
Garage
we're-
is in a totally different,
I think it's right next to.
Right next door.
It's right next door, so when you look at
that's
that,
that's in a zone break too, if
I'm
I'm
just
not
saying, but when you
mistaken.
look in that area specifically,
It's OR.
you could never,
That's OR.
you could never
OR too?
confuse that for any type of residential at all. It's commercial and.
No,
I'm just saying, specific to them, in regards to what they're attempting to do with the assistance of Larry, I don't know how many other options they have, and regrettably for them, they're only talking about, what, 20 feet away, for God's sake? I mean, you wouldn't need to move, have a moving company.
Yeah, the
Again,
auto.
having it next door, I understand, and I got no
Yeah.
problem with
You're
them
just looking
moving.
at the future,
I'm
but
looking at the
again, on
future
this
and the thing.
specific application, I can see why a special permit, and you can clearly see that it may or may not, to me, it's not the same as a Carl Bright or the dentist, because I think that's a much different, we're looking at a much different scenario on this specific one. So-
yeah,
And the
their
other,
issue, I don't think there's a problem. It's on.
And again, I gotta be honest with you, I'm sure we could sit here and fight about if the dentist came in, if this were successful, and you know what? It seems to me that I don't know how successful that, changing that for a special permit would be, but
Well, but
we're not
you-
here to discuss that tonight, it doesn't matter. You know, it
Oh,
doesn't
we are,
matter.
we are, no, that's not, that.
Well, we can't
We are
discuss-
here to discuss that.
Well, you can't discuss an application that may or may never come in, so, or a special permit that may or may never be
Well,
Yeah, but
requested.
we're discussing a zoning
The
change.
possibility of a,
in terms of Babe's question about the old ice house where the guy's auto use is now, that's a nonconformity. So he's got more protection than any of the rest of this stuff could ever give anybody. So that's not gonna happen. Whatever's gonna happen there is gonna happen in the context of a totally different section of the bylaw. So they have a right to request a special permit to change from one non-conforming use to another. So if he wanted to stop doing his auto repair in there or storing his own vehicles in there, he could request a a special permit to change to a retail store. And that has nothing to do with any of the rest of this at all. That's because he's a nonconformity.
Well,
That we created in 2010 when we did the OR zone.
I think it would be important, not that it's any more legal than anything else, but I think it would be important that that in the meeting minute notes, that we clearly indicate that the board had a discussion of the term residential structure and what the meaning of that is, so that if someone does ever come back, we can say, look, when we passed this, we specifically had this discussion, and the intent that this board agreeing to this was that those were structures that looked like residences, although they may not be being used as residents at the time. So that way, we have something to at least, if other people come in asking for a special permit, we have that as a tool for us to use.
And one of the things that I was trying to clear up when we were talking about what Babe was saying is, the other two buildings that he mentioned, at some point in my memory, I don't know about Bright, but they had been residential. They had been.
So
Yeah.
the dentist definitely,
Absolutely.
right, I don't
We
remember.
remember that.
Yeah.
Bright, I think, is a little bit before our time.
Yeah.
My only point was, the idea would be, that was exactly what we talked about when Larry created this. We weren't talking about buildings that had any history as residences at all. So we aren't talking about any of those kinds of structures. We're talking about a structure like this building.
And really, that's the only way that I would be for it, Ernie, to be honest, is that I
Makes sense.
Excuse me? Okay, you ready?
Any other discussion? Are we clear on what we want to do? I'll take a,
Anybody in the audience?
oh yeah, my apologies, being a public meeting, anyone in the audience, seeing none? Pleasure of the board.
make a motion, we send a favorable recommendation to town meeting.
Motion by Babe.
I'll second.
Seconded by, motion by Joe, seconded by Babe.
All right.
Any further discussion? Hearing none, all in favor, opposed, unanimous.
Thank you, ladies and gentlemen.
Thank you.
Have a good evening.
You do the same.
Take care.
Best of luck.
Yeah.
And Larry, you caught up? And finally, we have a discussion for town engineer vacancy.
Yeah, the various members had asked that I add it to the agenda. It's my understanding that there was at least consideration as to whether or not you want to send a memo to the Board of Selectmen suggesting
Inclusion of both
Inclusion of
a delegate from the planning board and conservation.
conservation, exactly.
Well, when we look for the last, after Mike Santoro,
Conservation.
Let the
do it.
conservation send their own, yeah. I mean, I don't know that we have the right to send
No,
it,
no,
but.
no. I'm only having,
right.
just for sense of purpose of what Larry's referring to.
Yeah,
Well, my feeling is that Joe was on that committee when they voted for Vonnie. He was on for the planning board, and I would suggest that he would be on that committee looking
We don't-
for.
We don't know if
we
they're
don't
gonna
have to,
have such a
we don't have to
committee.
worry about that
Is there a
yet.
committee yet?
No, there's nothing yet. There's been no,
That's
I
part
think
of-
based on the response we got back from the selectmen during that search, I think it's important for us to voice our views now as opposed to what we did the last time, because the Board of Selectmen was somewhat upset that we sent them a letter saying that we wanted to be on somewhat later in the process.
I remember
I
that.
was chair at the time, and the person who,
Well-
the person who seemingly was the most upset was at the time, what's Ricky's position?
Town
Official?
administrator.
The town administrator was more upset with us than the Board of Selectmen, because at the time, I recall distinctly that Brian Murray had called and suggested that it was a pure oversight, and that in fact, there had always been a delegate, and again, I'm only gonna reference back the conversation that he and I had, that there had always been a delegate, usually from the planning board and the conservation. That's why, so I think it was nothing more than an oversight, but with that said, I think there's, on a professional standpoint, obviously, us sending a letter to the Board of Selectmen and directly to the Board of Selectmen.
I think we should say it now.
Suggesting that we would, again, like to be part of the process as we have in years past, certainly would be more professional than, taking a wait-and-see type of stance, if you will.
Yep.
So if Larry, if you can craft a letter suggesting just that as professional courtesy and, I'm gonna say, past practice,
Yeah.
that there has been generally a delegate from the planning board, and that we would seriously hope that they would, consider repeating that process.
Well, there's a lot going on in the town, and we're not gonna have an engineer watching over
All you
everything,
do,
Yeah.
come and sign it.
you know?
And while you're there crafting a letter,
What are they gonna do?
you may also want to, probably from
meeting we're
yourself,
gonna vote on it.
but also from the planning board, suggest that an outside independent engineering firm would be extremely helpful.
Interim.
In the interim, not knowing what their timeline is and so on and so forth. And again, I'm assuming you should do the same from your own department, but as far as the planning board, if you could
Yep.
suggest that, like I said, hiring an interim engineering firm for
Well, I
our
can-
review
I can include
would be
that, yeah.
extremely beneficial to this board and the
Include
town.
that in the same memo.
Yeah.
Yeah.
Well,
'Cause they-
You know what, keep them
No.
separate, keep them separate, let's not confuse the issues,
Okay.
because I think they're
But you
two
should want 'em
separate.
both
I
to
think
go
they're
to the
two-
selectmen.
Yes, but I think they're two separate issues. One is our participation, and one, more importantly, is overview for this board.
Right.
Any other business? You content with the letters?
Yes, I am.
Motion by Babe, second by Joe, to adjourn. Thank you, and have a good night.